Hi, I'm Robert Fleming. I'm an attorney in Tucson, Arizona with the law firm of Fleming and Curdy. And I'm here to talk to you today about trusts and estate planning. And I want to be very clear as we start this out that I'm going to talk about Arizona law. Don't know very much about Montana law or Missouri law or Mississippi law or Maryland law or Michigan or any other state that doesn't begin with an M. We really know about Arizona law here at Fleming and Curdy. We are a firm headquartered in Tucson, Arizona, and we would like to help you understand the estate planning world for yourself and know what it is you need to do. So today the focus is on trust. Particularly, we want to help people who have already established trust to understand what they have done, what they need to do in the future, how it affects their estate plan. But much of what I have to tell you will also be helpful for people who are considering their estate planning and who are thinking that they might want to establish a trust. So just today, this first session, we're going to just talk about why you would establish a trust, or if you have already established a trust, why you did establish a trust and understand what some of the considerations are. So let's assume for a moment that you have signed a trust in Arizona. Why did you sign an Arizona trust? Well, one reason you might think is important is for taxes. Taxes, estate taxes particularly, are at this point in time only an issue for people who are quite wealthy. Less than 1% of the American public, far less than 1%, on the order of a tenth or 2/10 of a percent of Americans really need to worry about estate taxes on the federal level. Arizona doesn't have a state estate tax, and so you don't have to worry about Arizona state estate tax at all. There are some income tax considerations, but they're minor, and I don't want to spend a lot of energy on them today. In a later session, perhaps we'll talk about just the income tax consequences of trust planning under Arizona law. But from the larger question, estate tax concerns, it's just not a very big issue for most Arizonans, or for that matter, most people anywhere else in the country. And so that's unlikely to be the reason that you did your estate planning. And in fact, if you are in that less than 1% who have to worry about estate taxes, trusts are not the only way that you would address the estate tax concern. So that's unlikely to be the primary reason that you established a trust. Another common reason people consider doing trusts is to protect their children or their heirs or beneficiaries or whomever they're planning on leaving their assets to. And they can be protecting their children from a lot of different people. They might be concerned about protecting their children from themselves. Perhaps you have a child who is a spendthrift. Not a very attractive word, kind of an old-fashioned word, but it's an important one in the trust arena because it defines a kind of trust that is intended to keep your children from misspending the money, spending it too quickly, spending it on the wrong things, principally by giving control of the spending decisions to someone else other than your children. Although you can actually, in some cases, name your children as trustees of their own trust and provide some spendthrift protection for them. So you might be protecting your children from themselves. You might be protecting them from others. For instance, if you have a child who is a professional, an architect, a physician, a lawyer, somebody who occasionally gets sued for malpractice, or in a profession that gets sued for malpractice, or they have bad driving history, or you're worried about their ability to adequately cover themselves for their driving. You might be interested in protecting the child from other people who could sue the child, and that's when the spendthrift protections really kick in, even though the child may turn out to be the trustee of the trust. Another common place that people are trying to protect their children is to protect them from government intervention, and particularly from long-term care costs. So if you're particularly concerned about whether your child will have to pay for their own long-term care out of the money that you leave them, you might be considering a special needs trust as a way of protecting the children and really protecting them from government eligibility rules. So those are common reasons why you establish a trust, but not for most people the principal reason they establish a trust. Here's another one that is not the principal reason for most people. You might be interested in simply establishing a trust to allow somebody else to manage your assets. Maybe you don't particularly enjoy the management of assets and you'd like to turn that authority over to someone else, but you'd like to do it in a way that made it clear that they had responsibility to you. You continue to have the power to change the trust, change the trustees, do whatever else you want. Well, then you might be a candidate for establishing a trust for that reason. And so some variation of these three reasons are very common explanations for why people have already established an Arizona trust. But obviously, importantly, the big one is probate avoidance. For the vast majority of people who have already established a trust in Arizona, the primary reason, maybe the sole reason, that they have even gone to the trouble of establishing a trust is to make sure that their estates don't go through the probate process on their death, and that they save the cost and the hassle and the trouble of having to put up with a probate process. That's the principal reason that most people decide that they want to establish a trust in the first instance. And so if you have already signed a trust in Arizona, there's a pretty high likelihood that that is, if not the sole reason, at least the primary reason that you went ahead and created a trust. Even if your trust has been around for quite a while and was once motivated by tax considerations, the probate avoidance consideration remains the most important reason that you might have established, might continue the trust that you established some years ago. Before we really understand what probate avoidance looks like, we kind of need to know what Arizona probate processes look like. So let's talk for a minute about what it is you're trying to avoid when you use a trust to avoid probate. The principal question to think about is, will you have to have a probate proceeding to transfer your assets on your death at all? Most people who die don't have any probate proceedings in the years after their death. Why not? Because even though they may not have established a trust, they probably have beneficiary designations, or they have joint owners who have right of survivorship, or the property is held in community property with their spouse with right of survivorship. All of those kinds of assets transfer automatically without any probate process necessary. All that has to happen is that the person or the entity that's holding the asset needs to have a death certificate in order to make the change on their books. So in other words, if you have a bank account that says it's payable on death to someone else, on your death, all that person has to do is show up at the bank with a copy of your death certificate, and the bank will transfer the account to the named beneficiary. Same thing for real estate. Arizona allows beneficiary deeds to transfer real estate so long as it is in Arizona. Same thing for brokerage accounts or stock certificates. Arizona permits the titling to be transfer on death, TOD, so that no probate proceeding is necessary. And the same thing, obviously, for life insurance and annuities and all sorts of other financial assets. So here's how you know whether your estate will require a probate proceeding on your death. Are there assets that are in your name alone with no beneficiary designation whatsoever? If there are, we may have to probate your estate on your death. If there are not, whether you have a trust or not will not change that we do not need a probate proceeding. There is a special rule in Arizona that estates of less than $75,000, and for purposes of calculating this, we mean only those assets that are in your name alone that would be subject to the probate proceeding. If they're less than $75,000 total value, then it's easy to collect the assets without having to go through a formal probate proceeding. You just have to sign an affidavit that you're the person entitled to receive the assets, provide evidence of that, and most banks, brokerage houses, most other people will give you the assets of a deceased person based on that affidavit in Arizona, up to $75,000. So will you have to have a probate proceeding when you die? Only if you have more than $75,000 worth of assets in your name alone without beneficiary designations. For most people, They don't meet those rules, and therefore there won't be any probate proceeding on their death anyway. There is a lot of confusion about whether a probate is required because you have a will. We often have clients here at Fleming and Curti who say they don't want to sign a will because that requires that their estate go through probate. And that's not the case. Your estate has to go through probate if there are assets of more than $75,000 in your name alone, whether you've signed a will or not. All the will is direction to the probate court about how to divide your assets or how to distribute them. And it doesn't mean that you have to have a probate proceeding. So most people who do a trust, who create a trust, also sign what's called a pour-over will at the same time, a will that leaves all of their assets to the trust in order to take care of anything that might not turn out to be in the trust for whatever reason. And at a later session, we'll talk about how sometimes you still need to do a probate proceeding even after your heirs need to do a probate proceeding even after you have established a trust, because assets sometimes don't get into the trust's name or fall out of the trust. There's one more thing we have to appreciate about probate in Arizona, at least, and that is if we do have to do a probate proceeding because of your death, we will only have to conduct the probate as to those assets that meet the earlier description. Only those assets that are in your name alone without any beneficiary designation or any other provision for their disposition. And so if you have a $100,000 bank account at a trust and you didn't get the bank account into the trust's name, it's in your name alone when you die, yes, sure enough, we're going to have to do a probate in your estate, of your estate, but we won't have to probate those assets that are titled to the trust. We will only have to probate the $100,000 bank account and not everything in your name. So probate is not as bad a problem as most people think it is for a couple of reasons. One is it's relatively rare that people's estates have to go through the probate process because they tend to have beneficiary designations and joint ownerships and other arrangements that avoid probate. And the second is that most people, majority of people, die with less than $75,000 of assets that are subject to the probate process. By the way, a couple of times I've mentioned joint ownership, and yes, that is a way to avoid probate proceedings. You could just put your children's name on as joint owners on all of your bank accounts and on your brokerage account and on your house and on everything else you own, and avoid the probate process. But we do not recommend that as an estate planning alternative. Why not? Because when you put your children's names on, you've made irrevocable transfers. You can't later decide that you want to divide your asset in a different percentage or leave it to a different child. And a lot of our clients say, well, we're never going to change our minds. Yes, people do change their minds. The other problem is that you subject your assets to your children's creditors, to their spouses. What happens if the child dies before you? You may have created a situation where grandchildren suddenly are joint owners with you, or someone else that you didn't choose and don't approve of. So joint ownership is not a good substitute for thoughtful estate planning. You really need to do your estate planning in a much more thoughtful way than that. So that's kind of a quick overview of why you might have established a trust and what the Arizona probate process looks like. And that's where we're going to stop today. We're going to do another session later where we talk about trust terminology, and we introduce you to some of the particular language of trusts, what it means to be a trustee, what you call the person who establishes a trust, who are the people who receive the benefits of a trust, what different kinds of trusts are there. We're going to go through a bunch of definitional terms to introduce you to a lot of those ideas, and that will be showing up on our YouTube channel, youtube.com/elderlaw, at a later date, and we'll be looking forward to explaining that to you. Once again, I'm Robert Fleming. I'm an attorney in Tucson, Arizona, with the law firm of Fleming and Curti, and we've been delighted to introduce you to some of the notions of trust planning for estates in Arizona. Please remember that this is Arizona specific. We don't know the law of North Dakota, North Carolina, any of the states, regardless of what they start with, except for the state of Arizona. So do talk to, if you're not an Arizona resident, do talk to the lawyer in your state so that you get good advice under your state law. And we look forward to hearing from you. And we hope you enjoy this program, and stay tuned for later programs on some of the other topics that we will be touching on. Thanks.